Okay, we're back. This is going to be Rape of Justice by Eustace Mullins. This will be chapter 3, which is entitled A Plague of Lawyers. And I am on Facebook live with Brant Hunt, B-R-A-N-T, Hunt, H-U-N-T. I'm also on Odyssey live, and I'm also on YouTube, also live. So I welcome you back, and we're going to try to get into this particular chapter. This is probably going to be another long one as far as I can tell, so we'll just try to go through it, okay? So it's entitled A Plague of Lawyers. In his institute, Sir Edward Coke, C-O-K-E, defines a lawyer as one who is set in place of another. In the early years of the American Republic, many of the founding fathers were either lawyers or trained in the practice of law as part of their classical education. As a result, we have maintained the fiction that lawyers themselves are purchasers of unimpeachable probability. So much so that in the rare occasions when a lawyer absconds with a widow's funds, it was a moment of great shock. Such occurrence has now been relegated to the era of the old W.C. Fields comedies. That is, the lawyers no longer abscond with the widow's funds. They merely transfer them to their own bank account and then send the widow an enormous bill for service rendered. Charles Dickinson gave us the most memorable portrait of a lawyer's technique in his rendition of Uriah Heep. Servile, insinuating, and once he had taken your funds, overbearing and demanding. Dickens also posed the great problems endured by those who found themselves delivered over to the hands of lawyers. In his rendition of the case of John Deese versus John Deese, a legal struggle which went on for generations, beggary the clients but enriching the lawyers. Unfortunately for American, John Deese versus John Deese has proven to be the model on which our legal profession has modeled itself. Our courts are filled with similar struggles, the least of which may come to the decision in a mere 5 years. The RAND Foundation, that's R-A-N-D Foundation, recently completed a study of our legal profession, finding that soaring legal costs accompany delays in getting into trial, which now reaches an agonizing 18 months on the average. The RAND noted that half of the $30 billion annually spent on lawsuits goes to lawyers. That's $15 billion a year. And this was written, let's see, let me check the book here. This was written in 1989. So that has been 99, 2009, and it's been 30 years ago, over 30 years ago. 15 billion a year, much of which is created by deliberately prolonging the time and expense of litigation goes to these lawyers for shuffling a few papers. Their expenses rarely entail more than 5% of this amount. Consequently, hundreds of dollars powers, lunches, $50,000 a year memberships in country clubs, and many other prerequisites must be pursued in order to sop up the excess cash. When an American citizen hires a lawyer, he enters the office of the practitioner under the now defunct image of a professional as they closely akin to one's physician, into whose hands one delivers the vital question of one's personal health or of one's minister, who will be glad to cooperate in one's eternal salvation. However, just as the physician is likely to give you a new drug whose side effects will be worse than what is ailing you, or that a minister will divert your financial contributions to some tart in Harlock's Alley, the lawyer may prove to be even more devastating. Few people realize that associating with a lawyer may turn out to be the most dangerous step you can take, possibly resulting in the loss of your home, your job, your family, and life savings. They have no idea that lawyers often engage in one of the following practices during a single case of litigation: subornation, perjury, conspiracy to obstruct justice, and flagrant violation of the constitutional rights of the opposing party. Perjury, that is, false swearing an oath, is one of the most prevalent practices in our court, not only by witnesses, but also by judges. But also by lawyers, who often coach witnesses to repeat carefully directed and totally false testimony. I once appeared with an attorney in a traffic case in New Jersey, which went on for about 5 hours in a stuffy small town courtroom. No air conditioning, that is. At the end of the case, the judge who ruled against us informed the attorney that of all the testimonies heard that evening, his was the most incredible. subordination of perjury, that is, going over the prospective testimony of a witness and instructing him what not to say or what he should say, is the linchpin of our present courtroom drama. The adversary system of justice. Two pit bulls are released in the arena to tear each other until one sinks into death. This system has little to do with justice, but much to do with power, profit, and augmentation of fees. The practices arose because a lawyer who did not know what his witness might say on the stand would be sitting on a keg of dynamite, wondering when it would go off. Many cases which have been arduous prepared have been lost in a twinkling when a witness goes beyond the scope of a question and volunteers further information which destroys the client's case. For this reason, lawyers rely heavily upon pretrial depositions or pretrial discoveries. Once these are typed up and presented to the court, they are set in stone, removing the fear that the witness will volunteer extra information or alter his testimony. Like congressional speeches, which are daily reprinted in the congressional record, the testimony may be subjected to intensive editing, alteration, and deletion, all without any notice to the witness or the court. The altered deposition is then presented to the court after a lawyer's extensive changes as sworn testimony. Should an error be exposed, it will be blamed on the court reporter. The other tools of pretrial discovery are written interrogations, that is, and requests for admission, both which are also answered under oath. The interrogators constitute one of the greatest abuses of parties. They were sometimes expanded to as many as 50 or even 100 questions, some of which were so artfully phrased that the party who answered question 18 would be asked again to question 74, so that in answering it, he would totally contradict his answer to question 18. Amazing, these guys. Interrogators are always identified as continuing in nature, that is, first set of interrogators, following by second set ad infinitum. Some courts now limit the number of questions in a single interrogation to 20 or 30, but no correction of the abuses of continuing interrogation is contemplated. As I've repeatedly pointed out in motions from protective orders against depositions in the court, pretrial discovery is actually pretrial trial. The lawyer actually conducts the hearing with himself sitting as judge and jury with no actual judge being present. Judges have been universally hostile to my motions and always denied them, indignant that a layman would question one of the most probable and arrogant practices of the legal profession. I identified them as bills of attainder, which are absolutely forbidden by the Constitution, being too naive at the time to understand that the law merchant or admiralty procedure of our courts ban any and all constitutional protections of citizens. Pretrial discovery is also modeled after the ancient Star Chamber procedures. The subject of the deposition, is summoned to a room where he's placed under oath, with the understanding that anything he says may be used against him. As Roy Corner has pointed out, discovery has become the bread and butter of the legal profession. Previous forbidden by both common law and constitution, is now the sacred cow of our legal procedure. Legal authority Emily Garrett pointed out in an article in Albemarle magazine, July 1989, that lawyers in the state of Virginia have been able to engage in this probable practice since the early 1970s. She quotes Robert Taylor as stating, "Discovery takes a great deal of interest out of trial practices," further pointing out that it prolongs cases fivefold and makes them much more expensive. They're the devil, folks. Although we may think that the proliferation of lawyers and their willingness to abuse everyone is something new, a affliction peculiar to modern civilization, we have only to turn to the scriptures to find these warnings. Woe unto you, you masters of law, you snatch the keys of knowledge. And Jesus said, woe unto you, masters of the law, you heap great burdens on the sons of men, yea, loads by far too great for them to bear. Woe unto you, you masters of the law, you snatch the key of knowledge from the hands of men. You close the doors, you enter not yourselves, and suffer not the willing ones to enter it. His words provoked the Pharisees, you see, the lawyers and the scribes, and they, resenting, poured upon him torrents of abuse. The truths he spoke came like a thunderbolt from heaven. The rulers counseled how they might ensnare him by these words. They sought a legal way to shed his blood. This gospel offers striking insights into practices of the legal profession, not only in the time of Jesus, but even more so today. We should not honor this profession by calling it a practice of law, but rather as a subversion of the law, or as maybe I should say, the rape of the law, the all too familiar methods by which God's law is subverted and perverted by dedicated and professional criminals. Note the dictum. The rulers counsel how they might ensnare him by his words, just like what they do, you see. I have just identified this conspiracy as pretrial discovery. Further, they sought a legal way to shed his blood. This, too, is the goal of our legal practices. To protect American citizens from just such abuses, the Founding Fathers added certain guarantees, which they termed the Bill of Rights, protective measures which had been cited by Sir Edward Coke earlier in his Petition of Rights, and which had long been envisioned by enlightened European scholars. Of these rights, none is more important than the Fifth Amendment, which were personally authored by James Madison. The prohibition of self-incrimination. However, the legal profession has boldly circumvented this guarantee through pretrial discovery. They attempt to force a party or a witness to provide statements which will destroy his testimony and his case. The rulers counsel how they might ensnare him by his words. These are demons, folks. In so doing, they sought a way or a legal way to shed his blood. What does that mean? It means precisely what it says. They sought a legal way to shed his blood. When you go into American court, the legal profession seeks a legal way to shed your blood. No technique associated with this goal is too vicious or too base to be excluded from the arsenal of the lawyer, even though it is barely conceded purpose, openly approved by the judge, who is also a former lawyer, who sheds your blood. This may seem rather cold-blooded or even unchristian to the intended victim, who fails to recognize his dilemma. The court is a reincarnation of the ancient Roman arena, where the Christians are presented only because they are to be thrown to the lions. Their struggles provide amusement for the wealthy but bored spectators. The court has adopted the old Roman rule of absolute impartiality, extending compassion to none in the arena, whether plaintiff or defendant. Each of them is to be equally torn and mangled until only shreds are left on the teeth of the lion. The doctrine of legal immunity is also an important part of the Roman games, as our courts may more properly be known. The cheering audience sits high above the arena. No lion is strong or agile enough to leap into the seatings and present a threat to the spectators. Judges, lawyers, and the juries can safely watch the torment of the victims without fearing for their safety. Not a drop of blood will splash onto their citadel robes. This is justice, you see. Our jurisprudence demands that we hire an attorney to represent us because the legal system has grown so complex that only a highly skilled practitioner is qualified to present our case. There is some truth to this claim, but it is far from the whole story. In fact, civil procedure as is practiced in our courts can be learned in a few hours. We're speaking now of the basic practices. The ramifications of our civil procedure are in fact infinite. The present writer has contributed his modest addition to it by observing that under our present legal system, any case is in fact endless and can be continued ad infinitum, depending on the extent of funds of the rapidly impoverished parties to the action. This writer has found most attorneys not only unqualified, but unfamiliar with many aspects of legal practice. A discovery made when I repeatedly filed motions which attorneys, both in private practice and employed by government agencies, had no idea how to answer or to argue. Yes, it's done a certain way. See, they have a certain way to set this game up, and they play by that. But if you come along and create an issue, they don't know how to deal with it because they just practice what they always do. They don't really know the law, you see. Their way out of this dilemma was one on which they have relied constantly during this writer's 40 years of practice in the courts. They simply had the judge deny the motion without argument. The layman was explained, but that's impossible. The court's duty is to hear and to resolve all motions of the litigants. In a perfect world, this would be true. The dodge by which they ignore it is one of the most treasured privileges which judges have granted to themselves. It's called judicial discretion. It's just a way of, that's the way they are. The first line of defense for the judges is judicial independence. No one can influence the judge because he is absolutely removed from any possibility of influence, whether family, financial, or political. His second line of defense is judicial immunity, which means this is a claim that when a man puts on the black robe of the ancient physical ritual sacrifice of victims dating from the times of the cults of Babylon, he is placed beyond any criticism of retribution and removed from any liability for violations of morality, national loyalty, or religious concepts. As I stated in a letter to the press, October 12, 1985, the present practice of judicial independence, judicial discretion, and judicial immunity is intolerable in a free society. A judge is simply a monitor or a policeman who sees to it that the statutes are observed. No one can be immune from the consequence of his actions in a law-abiding society. In a previous letter, October 10, 1985, I noted that for 25 years I had filed suits in area courts in which the evidence in my favor was stricken or ruled inadmissible, while the evidence against me, including hearsay from many mental patients and patients with brain damage, was omitted. I have sued 4 attorneys, all which suits were dismissed on demurrers, meaning insufficient cause of action, which is barred by the federal rules of civil procedure. I went to the U.S. attorney with a list of 42 consecutive motions I had filed, all of which were denied, while motions against me were profundly granted. I later learned that this fellow was a political crony of our crowd. I never heard from him to this day. Of the 3 unholy practices of judges, the doctrine of judicial discretion is the most pernicious and the most frequently encountered. Briefly, this means that the judge has the option of personally ruling for or against any motion without going into the legal merits. He may also ignore it altogether by taking it under advisement. This means that he postpones his decisions for months or even years, leaving the case in limbo. His fellow members of the legal profession, the opposing lawyers, eagerly accept this announcement because their meters will continue to run throughout the period of the judge's monumental wrestling with the merits of the motion until he finally reaches a decision. In truth, little or no such wrestling ever takes place, you see. The judge merely buries the motion until the agonizing screams of the victims force the lawyers to request that he deliver his opinion. But what does all of this have to do with justice? Asked the gentle reader. The answer to that question is in the title of this book. It's not titled In Praise of Justice or the merciful qualities of justice. It is only the rape of justice which this writer is concerned. That is, those who are forced to submit to indignities for the pleasure and profit of others. Force, as in rape, is the backbone of all legal practices. Every order handed down within the confines of the American courtroom is delivered with a back of force. Armed bailiffs, I should say, stand on guard in the courtrooms, not merely to intimidate those appearing, but also to arrest, incarcerate, or even to beat or kill anyone who challenges what is taking place. The attorney whom you hire is a willing participant to this force. He never informs you. You see, he never informs you of this whole thing. When he hands you his bill, that he is bound as an officer of the court. You pay their fees, but the lawyer's primary obligation is to the court. That is, to the legal system and the practice of which it stands. And Witt committed that the Pledge of Allegiance for a lawyer should read, I pledge allegiance to the legal profession and to the criminality for which it stands. Sir Edward Coke's definition of a lawyer as one which stands in the place of another takes us back to a more open type of justice. In early civilization, the difference between citizens were settled by trial or by combat. The dissenters might fight to the death or until one is disinclined to continue. The triumph went to the battler who were left standing. Our boxing matches follows the same principles. The winner is the one who's still standing, who has outpointed his opponent throughout the bout. The victors emerged not only as champions, but also as leaders. This led to the hiring of champions to stand in for those not able to enter the list of whose obviously had no chance of winning. This is the reaction and deterrent for the hiring of attorneys today. Your lawyer is a hired gun who will go up against a faster gun in the West in your stead. The legal profession maintains that you have no chance of winning in our complex legal system. Therefore, you must hire a champion, an attorney, to appear in your place. From some 40 years of court appearances, I have never found myself in a legal situation which an attorney would have been better able to represent my interests than I could do for myself. The reality is that no attorney can represent you. As an officer of the court, he can plead or pray your case before the court. In other words, he intercedes with the imperial presence of the court in your behalf. He prays, P-R-A-Y, that the lines may be called off or you are torn to bits. He beseeches the court not to award damages or penalties against you, which are several times greater than your total assets, but to exercise mercy and reduce them to a sum only slightly greater than your entire net worth. This explains why the patron saint of lawyers in St. Matthew, that is in Matthew 5:40, he counsels, and if anyone would go to the law with thee and take thy tunic, let him take thy cloak as well. This is not merely as exhortation to turn the other cheek, but rather to allow the attorney who is making off with your tunic to turn back and appropriate your cloak as well. For this reason, I have advised my audience for many years that the ancient adage, a man who represents himself in court has a fool for a client, must be brought up to date with the admonition that a man who hires a lawyer is a fool. Few Americans experience any qualms at turning over the most intimate details of their personal and financial lives to a lawyer, yet the risk should be apparent to anyone. For years, I have counseled anyone who plans to meet with or consult a lawyer to take adequate precautions. The first precept: never discuss any details with a lawyer over the telephone. In one case, which drags on for 3 years, the opposing counsel, one of the most influential and highly paid lawyers in the state, repeatedly demonstrated that he believed he was dealing with a fool by calling me unannounced at my home in the afternoon and trying to obtain verbal commitments from me about various legal maneuvers in which we were engaged. I filed a complaint against him with the court. The judge never took any action, but it did stop the telephone calls. In almost every section in which I have been a party, I've had to file a repeated motions with the court, complaining about illegal procedures followed by opposing counsel, motions for reprimand. To date, none of these have ever resulted in a reprimand at all. The second precept which I offer is that you should never go alone to a lawyer's office. In recent years, books on legal problems have suggested you attain a signed agreement with your lawyer, agreeing on costs, etc., before engaging him to represent you. This would have been unheard of a few years ago. It's rarely requested even today because few lawyers would sign such an agreement. They would previously inform you that such an agreement would place too great a limitation on their ability to represent your case. Yeah, I bet. The lawyers want only a blank check from you, not an agreement, before his meter starts running. He will eventually fill in the blank check with the sum of your net worth. Also, when you go to the attorney's office, you would be wise to bring a relative or a trusted friend with you. I have taken as many as 8 people into judge chambers for motions hearings or into a lawyer's office for a required appearance. In every instance, the judge and lawyers have not dared to voice any objection or to ask, who are all these people? It is also wise to record any conversation with an attorney. Here again, most attorneys would object to this, as it places them on notice that you do not trust them, and ultimately places limits on the amount of damage they will be able to inflict, you see. A fatal mistake made by many citizens in their naive belief that because a lawyer is relative, a close friend, or a longtime neighbor, or a country club member, he can be trusted. In fact, you would probably be safer with a stranger handling your affairs, as thousands of widows and orphans could attest. Lawyers trade upon such association as relationships, memberships in a religion or fraternity organization, or any human contact which they can use to bring in the business. The Washington Post recently noted that an ambitious associate can generate profits to a firm of $200,000 per year on gross billings of $300,000. Note these figures. They indicate that 2/3 of the billing is net profit to the firm. Over 66%. They indicate that 2/3 of the billing is net profit to the firm, which costs amount to 1/3 of charges. The Post noted that large DC law firms pay associates with 2 to 4 years experience $85,000 to $100,000 per year in the salary range of the Attorney General of the United States. My, oh my. Wow, these people really are the devil. Partners of large law firms clients at $225 per hour, and this is 1989, while associates charged around $125 per hour. A typical 80-partner firm pays a mean income per partner of $360,000 per year on $938,000 of gross revenue, which means that the firm must gross $29 million annually, or $80,000 for every day of the year. Merely organizing a file, indexing the documents in a lawsuit can cost from $2,500 to $5,000, while the drafting and filing of a complaint costs upwards of $10,000. No wonder people sneer, "Sue me," knowing that few people can afford such expensive justice. Regardless of the merit of their complaint, a single motion before the court will cost from $5,000 to $30,000. The present writer sometimes files as many as 3 motions at a time during a period of maintaining 8 or more cases in state or federal courts. None of the motions were the 1 and 2 paragraph motions, such as those filed by opposing attorneys. My motion ran for 5 to 10 pages of documented legal arguments, with ample quotations from precedents and legal authorities. I discovered that the judges rarely bother to read these motions, much less allow them to be argued in court. They're all working as a team, folks. They work as a team. There are 4 members on that team, and that is the clerk of the court, or the court recorder, I should say. You have a defense, you have a prosecutor, and you have a judge. And all of them make money. They make money on a guilty plea or getting you guilty one way. And they all share in it too. They're despicable. In fact, the best thing you do is spit on them. They're not worthy of any respect at all. But unfortunately, we have these people who are lawyers. We had farmers or businessmen in the government, but we don't. We have lawyers who create moral laws to find ways of, quote unquote, finding you guilty about anything you see. Oral depositions are billed at $1,500 to $2,000 per day per partner, with half that fee charged for the ever-present associate, plus $300 to $500 per day for the court reporter and cost of the written transcripts. Litigation only a few months old can already have accrued costs of $50,000 to $100,000, with little or no progress being made towards a solution. In my 40 years of practice, lawyer's fees for the work I did for myself would have been billed at more than $5 million. To nip the growing tendency for citizens to appear as their own attorneys, lawyers have been urging the Internal Revenue Service to compute the legal costs of litigation for persons representing them, and then to tax the full amount as accrued income. To date, the IRS has not acted on that proposal. One of the legal profession's dirty little secrets in the frequent abuse of women by lawyers. Features have repeatedly been run on such magazine-type programs as 60 Minutes about sexual exploitation of women who find themselves alone in a lawyer's office. Here again, I must emphasize the danger of going alone to any lawyer's office. Whether you fear rape or not, you can expect the rape of justice to routinely take place. Whether physical rape or occurs or not, a woman who has been through a trying experience with her husband and who has reluctantly decided to seek a divorce is already distraught. Many attorneys are quick to take advantage of a woman who's already facing serious emotional difficulties. Before she knows it, she's awkward. She's awkward at his desk and undergoing an examination which she never anticipated. One Commonwealth attorney was finally removed from office after a series of complaints from outraged women over the period of years, forced reluctant officials to abandon their cover-up and to take action. Legal observers conjecture that perhaps only 10% of such incidents ever result in a formal complaint. These people are devils. They see themselves above the law. First, the victim realizes that despite the unwelcome nature of such attention, she is dependent on this lawyer to salvage some funds or property from her collapsing marriage. She's already established dependency merely by going into his office. If she storms out and goes to another lawyer, voicing her complaint about his behavior, that lawyer, the lawyer, because of his professional courtesy, is obliged to call his colleague and ask if the charges are true. His peer will drop a hint that the lady in question shows serious signs of being disturbed. She may wind up with no one to represent her. The iconoclastic writer Robert J. Ringer has inveighed forcefully against the destructive influence which lawyers inflict in the business world. He states that the proper time to lock legal men in his cage is when you are seriously about closing a deal. Like most of us, he learned about lawyers the hard way after repeatedly prevented the closing of the deal, in which he would have netted millions of dollars. He defines legal men as the omnipresent defendant of the non-existent problems of people, and is one of the players in the game of business who got into the part by sneaking under the fence, then took it upon himself to assume the role of a head skimmer. In short, in some 40 years of documentation documents the greater crimes which has been committed against the American people, I discovered that in every instance, at the very heart of each of these events, like a malignant virus, were the lawyers. John T. Flynn, writing in the New Republic, May 22, 1935, chronicled Professor William Douglas' address to a convention of lawyers in Durham, North Carolina, as follows. It is sad but true that the high priests of the legal profession were active agents in making high finances a master rather than servant of the public interest. So this is 1935, when there's a depression going on also. They accomplished what their clients wanted to accomplish, and they did it efficiently, effectively, and with dispatch. They were tools or agencies for the manufacture of synthetic securities and for the manipulation and appropriation of other people's money. In doing this, they followed the traditions of the guild. They never took seriously the nature of their public trust. They're above reproach, folks. That's why you don't need to vote for these clowns. In fact, you don't need to. Voting is consent. The New Republic further commented on these statements. These great law firms had guided their greedy and acquisition clients through the mazes of trickery that the financiers had not the wit to travel alone. No cause seemed too reprehensible for the lawyers to gild with their own sadly tarnished respectability. When you suggest a course of action to a lawyer, the usual response, "Oh, you can do that. You can't do that." You see, this response is almost automatic because it is incumbent upon every lawyer to discourage any client from striking out on his own strategic course. He must place his destiny totally in the hands of the lawyer, no matter how incompetent that attorney may be. Also, they are very reluctant to guarantee results from any course of action. Of course, in his heyday, financier J.P. Morgan complained that no matter what he proposes, lawyers would tell him he could not do what he wanted to do. Morgan said, "Mr. Elihu Root is the only lawyer who tells me how to do what I want to do." The result is the compliance was that Elihu Root became the preeminent lawyer on Wall Street. Financiers flocked to his office when they discovered that no matter what manipulation they could devise, Root was capable of coming up with a legal, acceptable formula to allow them to get away with it. Okay, so you see, he finally became the patron saint of American corporations by far when he worked out the strategy of setting up tax-exempt foundations for millionaire entrepreneurs who wish to preserve not only their money, but also their power. J.P. Morgan later chose Elihu Root to set up the Ag-Prop operation, the League to Enforce Peace, in 1916. His purpose, notwithstanding his seemingly pacifist title, was to involve the United States in World War I. It later took the name of Carnegie Endowment for International Peace, headed by Alger Hiss, who was a communist spy, who later went to prison for committing perjury when he lied about his handling of the secret documents to the Soviet agents. After World War I, Root became the honorary chairman of the newly establishment, the Council of Foreign Relations, which had been set up as the American branch of the Rothschild Policy Group, the Royal Institute of International Affairs in England. Elihu Root is also remembered as the man whom President Wilson sent to Russia, that's right, in 1919, with $20 million in cash to bail out the collapsing Bolshevik regime. Folks, the communist regime would never survive if it hadn't been for the West supporting it. The Europeans helped it out, and the Americans helped it out, either the bankers or the industrialists. The money was taken from the $100 million special war fund, which Congress had appropriated for President Wilson's use. Oh, my God. You remember, this is during the Federal Reserve System deals, too. Already is taking place because it took place in 1913. So the record of this exposition of the $20 million by Root's special war mission to Russia is recorded in the Congressional Record of September 2nd, 1919, as authorized by Wilson's private secretary, Joseph P. Tumley. However, it is Root's role as the legal mastermind of the charting of the influential tax-exempt foundations, which has laid his dead hand upon the throat of all living Americans. In 1909, he drew up the legal charter of the Carnegie Foundation as his principal incorporator. His fellow incorporators were Frederick A. Delano, which is the son of China's most famous opium dealer, Cleveland H. Dodge of the National City Bank. That's right, folks. You heard that. These people were involved in opium trade immensely. That's where most of these families made their money too, folks, by getting people hooked on opium. That's why also the reason why the United States was in Afghanistan, and also the reason why we were in Vietnam. It had nothing to do about freedom, folks. Your government is despicable. Well, it's not my government. And financed Wilson's presidential campaign and a longtime Rockefeller henchman, Daniel Coate Gilman, who had been trained by the German Illuminati in devious techniques of subversion. Gilman also incorporated the Russell Sage Foundation, another vital undercover operation. Elihu Root then incorporated the Carnegie Endowment for International Peace in 1921. His assistant, Philip Jessup, ran the CEIP after Alger Hiss was sent to prison. The aptitude of the great corporation law firm and the Wall Street firm of Sullivan and Cromwell, its founder's background, provide ample proof of the ruthless nature required if one is to succeed in this bandit profession. The Cromwell who founded the firm, William Nelson Cromwell, who publicly denounced on the floor of Congress as the most dangerous man in America. This description was not the prose of some reckless demagogue. It is to be found in a document published by the Congress of the United States, a 736-page volume. The Story of Panama, the House hearings on Panama in 1913. In September of 1904, during the absence of Secretary Taft from Washington, Mr. Cromwell, a private citizen, practically ran the War Department. John F. Wallace, chief engineer of the Panama Canal, testified before the Senate Committee on February 5, 1905. Cromwell appeared to me to be a dangerous man. In those hearings, Congressman Rainey was quoted as following: "The revolutionists were in the pay of the Panama Railroad and Steamship Corporation, a New Jersey corporation. The representative of that corporation was William Nelson Cromwell. He was a revolutionist who promoted and made possible the revolution of the Isthmus of Panama." Remember this key is that there was no Panama, folks. It was all Colombia. This was a country, Colombia, who came all the way up to where Panama is today. Okay. And he succeeded in getting these people to revolt against Colombia and actually separate and create another country in order for them to build the canal. How much devious can you be? At that time, he was a shareholder in the Railroad and in General Counsel of the United States. William Nelson Cromwell, the most dangerous man this country has produced since the days of Aaron Burr, is a professional revolutionary. And you thought lawyers were dull? Congressman Rainey used language which we might expect to describe Leon Trotsky or Al Capone. However, he was talking about the founder of the most august law firm on Wall Street and what had been the history of that firm since the passing of its notorious founder. Cromwell trained and produced a protege who outstripped his predecessor, that is, the famous John Foster Dulles, a relative of the Rockefeller family. Dulles was closely linked with international espionage groups headquartered in Switzerland and in England. He can be described as the architect of the Second World War, as well as the man who single-handedly issued the orders which precipitated the Korean War. At the Paris Peace Conference in 1919, the senior partner of the J.P. Morgan Company, Thomas Lamont, wrote, "All of us place great reliance upon John Foster Dulles. History proved that this reliance was not misplaced." In 1933, when a victorious but penniless Adolf Hitler needed funds to build his Nazi regime, his personal banker, Baron Kurt von Schuler, arranged a private conference with Hitler at the Schroeder residence in Cologne, Germany. Attending this meeting as a representative of Kuhn, Lowe and Company and other Rothschild interests was John Foster Dulles and his brother Allen Dulles, who later founded the Central Intelligence Agency. That's who they are, folks. You need to know these things because the details are in the pudding here. The bankers, through their emissaries, guarantee Hitler the funds to install his Nazi government. However, this did not mean that they were Nazis or friendly to the precepts of Nazis. They were bankers who were making a sound investment in a coming event, that is the Second World War. Remember, nothing happens by coincidence, by coincidence, folks. It happens because it was planned that way. That's a quote from Roosevelt. Whatever one's feelings might have been towards Adolf Hitler, there was no escaping the fact that without him, there could be no Second World War. The governor of the Bank of England, Sir Montague Norman, whose financial manipulations precipitated the Great Depression of 1929 to 1933, was one of the first bankers to acknowledge the situation and to advance Hitler funds from the Bank of England. Remember that money also came from the United States, since we now we have the Federal Reserve System, which is not federal, not reserve, and it's not a system. It's crookedness, folks. That's all it is. During the 1920s, John Foster Dulles brought to Sutherland and Cromwell as clients the blue chip firms of Wall Street, J.P. Morgan, a National City Company, Dillon Read, W.A. Harriman Company, and Brown Brothers, which later merged to form the firm called Browns Brothers Harriman. Dulles' instant stature as a senior partner of the nation's most influential law firms reflected a truism of the profession, that the senior partner of such a firm is merely the one who has the greatest credibility. His word will not be challenged, his authority will not be denied, and when he exerts his influence on behalf of a political candidate, a church, a university, or any institutions, funds will be raised and the goal will be reached, you see. Behind this facade of respectability are the facts that such senior partners have been and are deeply involved in the greatest international swindles and acts of treason throughout the 20th century. They attained the rank of senior partners precisely because they had the talent of telling the most outrageous lies with the highest degrees of credibility, whether they are launching a securities issue of the campaign of a candidate for the presidency of the United States. John Foster Dulles ensured his place in history by sending a telegram from Tokyo to President Truman. It appears that the South Koreans cannot repulse the attack. Then we believe that the U.S. forces should be used. It was this telegram which Truman used as the authority to plunge the United States into the Korean War. The use of the imperial we, by Dulles notifying President Truman that the most important leaders of the world order wanted this war, he had no choice but to obey. Dulles was rewarded for this extraordinary act by his appointment to one of the nation's most influential posts, the presidency of the Rockefeller Foundation. Ostensibly a charitable organization from its inception, the Rockefeller Foundation was planned by John D. Rockefeller and his legal advisor, that's right, Elihu Root, as a business operation using extraordinary means. It is more properly described as a syndicate, which was the term Rogel used to describe a trust. Rogel further described a syndicate as a cartel or a monopoly, which also is an accurate description of the Rockefeller Foundation. The purpose of the foundation's charter was to perpetuate a corporation in perpetuity by removing it from any threat of a takeover by other interests. In a world in which everything is for sale, the shares of a corporation are the most sellable items of all. This means that no matter how profitable and powerful a corporate entity you may build, it can be bought out from under you by anyone who can raise the necessary funds. It was Elihu Root, brilliant contribution to the future downfall of American industry that a tax-exempt foundation would forever remove the possibility of any outside forces capable of buying control of the corporation. That meaning Standard Oil, the Rockefeller Oil Trust, places controlling shares in the Rockefeller Foundation in 1913. Interesting year, 1913, wasn't it? They remain there today. They're insulated against any outside threat. They've tried many times. Actually, Congress has tried to get those funds from them, and they can't get them. They fail. They remain there today, insulated against any outside threat. The foundation gave Standard Oil an enormous financial advantage over its competition. As Congressman Wright Patman, which was from the state of Texas, chairman of the House Banking and Currency Committee, pointed out in remarks before Congress, while it could not be swallowed up by any other company, it could proceed uninterrupted on its course of swallowing up or dominating its rivals. The impregnability also made possible its profitable cartel agreements on monopolistic firms in other countries, such as the historical 1926 agreement with IG Farben in Germany to control the world's chemical business. By the way, IG Farben and Standard Oil worked out a deal. You see. Later on, basically, that they discovered that you could produce coal, you'd have coal, and you could produce oil out of it. In the World Order, I painstakingly traced the background of the officers and directors of the Rockefeller Foundation from 1913 to the present day. Very few of these directors had any background in charitable work. However, most of them had very impressive backgrounds in such organizations as humanitarian endeavors as chemical warfare, international espionage, munition manufacturing, cartel agreements, and so forth. On the whole, charity was lacking in their resumes. Although society has been, on the whole, however respectful of lawyers in recent years, mindful of their power and their ability to inflict grief on their critics, diligent investigations disclose a few rare expressions of doubt in national organs of the media. Harvard Magazine, October 1976, featured an article called A Plague of Lawyers by Jerome S. Auerbach. He noted that the Constitution of Carolina declared it a base and vile thing to plead for money or reward. The states of Massachusetts and Rhode Island prohibited lawyers from serving in their colonial assemblies, a striking contrast to today's situation. Folks, I've done a video on the missing 13th Amendment. It was to deal with getting lawyers out of the government, and it was passed too. And it was law until Abraham Lincoln came to power, and he just pushed it away. The missing 13th Amendment. Look up a guy named Dodge, and you'll find out the information. He did all the research. We've been lied to about everything, folks. The states of Massachusetts and Rhode Island prohibited lawyers from serving in their colonial assemblies, a striking contrast to today's situation, as we find that 90% or more state legislators are now members of this legal profession. The historian Cravacoria described lawyers as weeds that will grow in any soil that is cultivated by the hands of others. A plague of lawyers, they would say. And once they had taken root, they would extinguish all other vegetation around them. They would destroy people's lives. The historian Ferdinand Lundberg wrote in Harper's in April 1939 about the priesthood of the law, in which he describes the purchase of the law. Lundberg quoted a historian case, Gebhardt versus United Railways of St. Louis in Missouri, 1920, in which the decision noted that the law does not make a law office a nest of vipers in which to hatch our frauds and perjuries. A withering comment on the legal practice which had come to light in this case. The Saturday Evening Post, December 2nd, 1933, noted in an editorial that when the Attorney General of the United States finds it necessary in addressing an anti-crime conference to refer to unscrupulous lawyers who aid and abet crime, the historical mouthpiece, that is editor's note, criminals and employing every artifice in their defense, the public cannot fail to realize that in relation between lawyers and crime, it faces a problem at once peculiar and obvious. The Attorney General went on to say that there is a reason to believe that in many localities a certain number of lawyers are in touch with and regularly employed by the criminal element, being the scavenger of the bar. We find connivance and connection between lawyers and crime with the concomitants of jury fixing, bribery, and perjury. One of the most astounding examples of legal conspiracy of Americans is described in the exhaustive detailed book Senatorial Privileges by Leo Damore, D-A-M-O-R-E, from the Regency, R-E-G-N-E-R-Y, 1988 book. The nation's leading journals have resolutely ignored this document work. Damore relates the amazing story of a famous lawyers sworn to the mafia code of Omerta, O-M-E-R, or silence, which forms around Senator Edward Kennedy and his conspiracy to obstruct justice shortly after the body of a young woman who was said to be pregnant was found in his abandoned car. The DA in this case was Edward Dennis, D-I-N-I-S, later publicly denounced the jury system in the state of Massachusetts as absolutely discriminatory and a systematic denial of justice throughout Massachusetts. He also attacked the scandal-ridden probate court system as a little-known citadel of judicial patronage and favoritism operating in an atmosphere of intimidation. The Chappaquiddick innocent as Kennedy escapee came to be known in the national press not only destroyed Kennedy's chance of being elected president, it also destroyed the journalist career of Roger Mudd, who was already accepted as the coming heir to Walter Cronkite. When Mudd interviewed Kennedy on September 29, 1979, he asked the fateful question, do you think, Senator Kennedy, that anybody really will ever fully believe your explanation of Chappaquiddick? Kennedy made the equally faithful answer that he found his own behavior beyond belief. Liberal factionists vowed to get Mudd for having exposed their champion in the list, and he was subsequently dumped by the network in favor of Dan Rather. He asked a question he was not supposed to ask, folks. None of us knew that, though, did we? The writer said, this writer was exposed to the true character of the legal profession early in a writing career. As attorney accomplished me to an attorney afternoon outing along the Garden State Parkway in New Jersey, enjoying the openness of the newly completed superhighway. I was tooling along in a new Hudson at a comfortable 95 miles per hour when I was surprised to see a black Chrysler drawn up beside me. The young trooper motioned to me to pull over. When we stopped, the attorney hastily drew out his card and handed it to the trooper. He took one look at it and said, okay, but added plainly as he drove away, but try to hold it down, will you? This same lawyer asked me to accompany him to a courthouse in a small town, ostensibly to do some legal research. When we went into the deserted record room, he asked me to wait by the door in case the Salmonati clerk wandering in. I stood there while he calmly ripped out several documents from the file and walked away. Holy shit. I expected that we would be seized and sentenced to serve at least 10 years. But we walked by the clerk, nodded a brief thanks, and were on our way. I later learned that it is customary for lawyers to delete records in this manner, to alter entries or to prepare substitute pages, which are then inserted in the files to replace the genuine ones. Whatever is on paper can be forged or destroyed. This I discovered in the unwritten motto of the legal professions. Do you see what kind of wicked people these are, people? That's why the scripture is very clear. It says, well-intended lawyers. Justice must be handed down to these people, too. On October 5th, 1988, the Washington Post headlined a feature of lawyers. Lawyers on drugs create problems wrapped with legal and moral questions. The gist of the story was that cocaine was becoming an increasingly serious problem among lawyers practicing in our nation capital. One attorney admitted to the press that he frequently represented his clients in court while he was high on cocaine, stating that while he was under the influence of the drug, he felt like nothing could go wrong. Another addict, Richard Winters, said, the thing that is really tragic in the legal system is this concept of the officer of the court as a superhuman man. This is what keeps a lot of lawyers who are addicts, either alcohol or substance abuse addicts, locked up in their closets and unable to say, Christ, I have a problem. Somebody please help me. The same issue, the Washington Post recounted the story of immigration attorneys accused of preparing documents for illegal aliens designed to defraud the Immigration Service. In her document work, The Trial Lawyers, Emily Gouric, Gouric, chronicles some of the successful techniques of the nation's most famous attorneys, among them Howard Wiseman, who won acquittal for John DeLorean on charges of conspiring to distribute cocaine by first filing some 50 procedural motions, including freedom of information requests. Wiseman knew that the judge would probably deny all or most of them. This process is informally known as exhausting the court. It is well known among lawyers that judges have a very short attention span. By flooding them with a mass of procedural motions, the lawyer can usually beguile the judge into a state of passivity, allowing him to proceed with a strategy for the defense of a client who's probably guilty. It is a truism of American justice that only the guilty can afford a really good lawyer. The innocents must content themselves with someone from the third or fourth echelon who has discouraging records of lost cases. Gouric also describes the tactics of the famed tax lawyer named Richard Racehorse Haynes, who represented Fort Worth millionaire T. Cullen Davis in his notorious Smith and Wesson divorce. As Texas-style divorces are known, she also gives us author Lyman, who was featured in a TV series, The Moscow Show Trials. As the North hearing before Congress was later described, Lyman had been a protege of Nelson Rockefeller in an investigation of the Attila prison riots and killings. He is partnered in the Wall Street firm of Paul Weiss, Rickon, Warner, Garrison. Lyman's clients included takeover tycoon Carl Icahn, Lazar Fares, I know who that guy is, the investor bankers, and Pennzoil, which won a $10.5 billion judgment against Texaco, despite his role as a chief counsel of the Iran-Contra hearings. Lyman recently stated on an op-ed page of the Richmond Times, "We do not have political trials in this country. This would come as news to Colonel Oliver North." Outraged clients find in many states, or most states, it is impossible to find a lawyer who's willing to file a suit against another lawyer. Theoretically, no, it's a country club work. It's a good old boy system, folks. It's worse than that, though. Theoretically, lawyers have no more immunity against lawsuit than anyone else in practice. Membership in a bar association, a law firm, or a Masonic lodge usually prevents or discourages a lawyer from taking a case against another lawyer, no matter how flagrant the offense may be. This was demonstrated to me in the case of the wife of a wealthy entrepreneur. Unknown to her, he had built up a $1 billion operation. After he decided that his new wealth required him to have a companion whom he could flaunt his public, he began to spend most of his time with his mistress. The wife sued for divorce, hiring a lawyer also, for reasons never revealed, placed himself on the side of the wealthy and influential husband. She stated that her lawyer summoned her to his office for a conference with her husband's lawyer. Her attorney then requested that she sign a stack of seemingly routine papers in their presence. Oh my God. Hidden deep within the stack was a document stated that she hereby relinquishes all claims against any of her husband's property. She read it and refused to sign it, though, even though her own attorney had conspired to give her to do so. Although she was unaware of the ways of the business world, she was not stupid. Nevertheless, she did not fire her lawyer, but allowed him to represent her through the divorce procedure. The layman finds that it is extremely difficult to fire a lawyer for cause due to court procedures, which are designed to protect the legal profession, another little-known aspect of our medieval legal system. You discovered, as I did, that you cannot fire your lawyer, your attorney of record, as he is known to the court, without the permission of the court. What that entails is that you must find a lawyer to represent you in appearance before the court, in which you request or pray to the court to allow you to discharge your previous lawyer and hire this one. The procedure requires that you hire an attorney to file a motion that you wish to fire your first attorney. This is a bunch of bullshit, isn't it? This motion is then argued before the court. Had she been appearing as her own lawyer, she could have done this herself. But few people are willing to risk everything in an archaic legal system by such an appearance. After hearing the motion, the judge then can exercise his judicial discretion as to whether he should allow you to fire the lawyer who has been selling you down the river. Such a motion is usually granted with the stipulation that you must be sure to pay the fees of the lawyer who was misrepresenting you, as well as the fees of the lawyer who is now representing you. This unfortunate lady wound up with a mere 20 $1,000 settlement from her husband. The lawyer claimed this was all he could get from him. Her husband then called her up to taunt her and followed. You don't know I was a millionaire, did you? She was enraged to find that he was indeed worth millions, which would now be lavishing on his mistress. She immediately resolved to sue her lawyer for malpractice. She told me that for months she traveled the entire state trying to find a lawyer who would sue this attorney who had robbed her. She was always given the same standard procedure. You have already accepted the settlement through your attorney. There's nothing I can do to help you. I informed her that I had been aware for years that no lawyer in the state, as well as in most states, will take a suit against a federal lawyer. The Bar Association claims it will hear complaints from civilians against a lawyer, but in actual practice, such complaints are promptly buried, never to be exhumed. I informed this lady that I had sued a number of lawyers in the state, acting as my own attorney. All of these suits were promptly thrown out by complacent judges on this technical known as demurrer, legally making a claim that there is insufficient cause of action, but in reality, it's legal jargon saying, so what? The entire text of my complaints against these lawyers have been copied verbatim from the statutes. One judge grinned at me and challenging remarked, you know, Mr. Mullins, no one can expect to win every suit. I could have risked a contempt citation by replying contempt citation by replying that I would like to win one in 40 years of pleading, but I said nothing. I had already reported that the self-same judge for dismissing almost 50 consecutive motions without argument, only to find that the federal attorney was one of his old pals. That complaint was buried, along with most of my other legal pleadings. I attained some small satisfaction from these lawsuits against our sacrilegious legal profession. When one of the lawyers came up to me at the door of the judge chambers whining that during the last 2 years, my suit against him had caused his malpractice insurance to double. Small victories are better than none at all, you see. The filing of lawsuits against lawyers by disgruntled, betrayed, and cheated clients remain one of the greatest untapped oil fields of jurisdiction of the United States. On November 5th, 1986, the Wall Street Journal carried a front page story about one maverick lawyer, Edward Freeburg, who has tapped this field and found it very profitable one. Freeburg, a lawyer practicing in Sacramento, California, gleefully sues his colleagues when clients inform him of their malpractice. The statement that this is untapped oil fields is proven by Freeburg's assertion that 80% of his malpractice cases against other lawyers are settled before trial. Only 17% ever go to trial. The reason was obvious. The lawyers were guilty and they did not dare to face a jury. Freeburg said he had a great advantage in suing lawyers and forcing them to take the stand in their own defense. Juries hate lawyers. We rank just above used car salesmen. Besides, lawyers are lousy witnesses. They talk too much and they're too arrogant. Despite Freeburg's enormous financial success, he wins millions of dollars award for his clients in these malpractice suits and takes 1/3 plus expenses for his contingency fee. No champion of the public has dared to enter the list in other states. Certainly other lawyers are aware of the thousands of cases begging to be filed for legal malpractice, but the profession has closed ranks. It's not merely professional courtesy. It is the fear that the entire profession will be imperative and perhaps destroyed if the public was allowed to go into a court with the ample document cases of malpractice. The State Bar Association and the Masonic lodges will never permit their members to do what Freeburg has done. Once the extreme cases of malpractice, negligence, and conspiracy get struck, justice begins to be argued in the courts. The profession is doomed. The lady whose divorce case was previously cited, like most clients, was unaware of one legal tactic, which is always to fasten to the cause of the litigant. This tactic is called an advisory meeting with the attorney for the opposing client to discuss the ramifications of the case. How long would it take? What sort of pretrial discovery is contemplated? And much important, how much each of them can milk his client before bringing the case to its predetermined conclusion. Such conference, known as ex parte, that is, without the parties and without their knowledge or consent, may include meetings with the judge to privately discuss the case. Ex parte is one of the most flagrant abuses of the present-day legal profession and is strictly forbidden by law. A few indictments for this practice have surfaced in the last decade, but the chances of a lawyer being prosecuted for engaging in an ex parte discussion are still closer to his chance of being struck by lightning. By statute, private citizens are forbidden by law from filing any paper with a court. unless they have previously filed the case themselves, thus notifying the court that they are an attorney of record and are representing themselves. In recent years, emphasis has been placed on filing in proprio persona as a proper person rather than an attorney pro se, the theory being that one thereby escapes being tainted as an officer of the court or being subjected to the jurisdiction of the court. However, anyone who enters a courtroom is presumed by the sitting judge to be under the jurisdiction of his court. And those who deny it can protest all the way to their serving of a 6-month sentences for contempt of court. That's correct, folks. You better make sure you know what you're doing when you go into there. Because if you don't, you can get in big time trouble. I'm not playing around. They can do that to you. And if you sign a piece of paper saying you're going to be there or whatever, it's curtains. So the language of statutes prevent any clerk of the court to accept any paper for filing unless it is submitted by a licensed attorney or a person representing himself. You may have a document which you believe will help your case. If your lawyer decides not to submit it to the court, you have no recourse. Your attorney will try to pass it off as irrelevant, although it could win your case, you see. Like I said, they're working together, folks. That's what they do. They're all on a team. They play games. The problem is that your attorney has already agreed with the opposing counsel to watch you wash away down the drain. Yes, you must accept his decision because the public education system carefully trains you to accept whatever professional man tells you without protest. Your doctor will tell you that vaccination is good for your child. Your banker will tell you that the Federal Reserve System is not privately owned. And your lawyer will tell you that he has your best interest at heart. These are lying piece of shit, people. They are. And I don't care who they are. A doctor telling you to take a vaccination is a fucking lie. These are evil people. Evil. Very evil. In recent years, public statements have surfaced which question the competency of American lawyers. Let me just say one more thing. Here. I'm going to also include, I know that Eustace Mullins is a Christian, but I'm not. And I believe it simply is not only that simply a doctor, a banker, and a lawyer, and a priest are all in the same boat, folks. All of them. Okay? Because they all deceive you. You're already a child of God when you enter this place, okay? Period. Your doctor, all he cares about is the paycheck. Your banker, the same thing. And the lawyer also. There's 4 people. And all 4, in something, well, 3 of them out of the 4 were actually spoken about Jesus. He didn't speak about doctors, but he did speak about bankers. He spoke about people who are religious. He spoke about lawyers. If Jesus was even a person, who knows? In recent years, public statements have surfaced which question the competency of American lawyers. Chief Justice Burger of the Supreme Court stated that American lawyers are incompetent. President Jimmy Carter warned that 90% of our lawyers serve 10% of the people, which is probably a break from the other 90% of would-be clients. Nevertheless, American lawyers show no competencies in conspiracy to obstruct justice, conspiracy to subvert perjury, or their ex parte meetings during which they agreed to sabotage their clients for the common weal. This writer has observed for 40 years that American lawyers are extremely competent in carrying out the abuses of the public, which has enriched them throughout the 20th century. I think the best thing to do is to pronounce curses upon these people. They're not worthy of anything, folks. I'm serious. You never call these people your honor. They're not your honor. They're not. They're dirty. The ABA, the American Bar Association, issued a carefully weighed statement that it has long been aware that the middle 70% of the population is not being adequately served by the legal profession. This may be a warning to the professions that our lawyers are overlooking 70% of the available market. The almanac shows some 651,000 members of the legal profession in the United States, including judges. Of this number, the ABA has enrolled some 335,000 members. In theory, the American Bar Association is merely another professional group whose function is to promote the practices of its profession. In fact, the principal function of the ABA, its states, units, and its local bar association is to form impenetrable phalanx for the protection of its members from punishment for their transgression against the public. And they know they're doing wrong. These are wicked people, folks. These are wicked people. These transgressions include not only offenses committed against individual members of the public, but also crimes by lawyers against the public weal and the common good. Many decisions obtained by lawyers through malpractice of their profession serve not only to injure individuals, but all members of the public as well. Anyone who has ever filed a complaint against a lawyer with a local bar association can testify that the complaint is met with thunderous silence. Once filed, it is never to be heard again. Public commissions have repeatedly verified this claim by releasing their findings. Former Justice of the Supreme Court Tom Clark headed a commission which, after 18 months study of the legal disciplinary system, published its findings that the prevailing attitude of lawyers towards discipline enforcement ranges from apathy to outright hostility. Discipline action is practically non-existent in many jurisdictions. We are given an official conclusion that there are few, if any, areas in the United States where a citizen can attain any satisfaction after making a complaint against an attorney. The Clark Commission noted that 90% of complaints against lawyers are dismissed without any person bothering to investigate the alleged facts. If you live in Sacramento, you might be able to hire Mr. Edward Freeman to handle your complaint against an attorney if there is a sufficient damages involved. As for the rest of the United States, you can save yourself a stamp by not writing to the local bar association. It is enormously key that the white-collar crimes are immense, folks, immense. Outrage of the known abuses of the legal profession caused New York legislation to set aside $840,000 to fund a disciplinary proceeding against lawyers. However, disposal of these funds were left entirely to the discretion of the private New York City Bar Association, which has sole authority to hire or fire all employees entrusted with the handling of disciplinary actions against lawyers. As could be expected, the $840,000 was turned into another boondoggle for the lawyers, providing salaries for their relatives with the understanding that they would do absolutely no work on the job. One of the most colorful opponents of the legal monopoly is Andrew Melnick-Kontinsky, the founder of the Constitutional Revival Movement, which is headquartered in Fairfield, Connecticut. In his literature, Melnick-Kontinsky forcefully states, yes, Virginia, there is a conspiracy. The driving force of that conspiracy is the bench/bar monopoly, a man who is willing to stand behind his beliefs. Melnick-Kontinsky regularly patrols court buildings wearing a large badge which reads, lawyers, judges, and politicians are scum. And they are. Note that he does not qualify this document. It does not read some lawyers, judges, and politicians. No, they're all fucking scum. Actually, they're worse than, quote unquote, a used car salesman, folks. You see, you at least get a car. It may not run, but at least you have something, you see. These people rob you. His characterization is all-inclusive. As an editor, I carefully analyzed his statement. I found that despite the most stringent editing, nothing can be either added to or subtracted from it and make it more direct. Melnick-Kontinsky also pickets courthouses and law schools, bearing a large sign. The court system is ultimately corrupt. One does not do this sort of thing in free America without consequences. Melnick-Kontinsky has been thrown in jail, but his vast knowledge of constitutional procedure always secures his release. There should be a Melnick-Kontinsky patrolling every courtroom in the United States, but so far he has carried on his crusade alone. Texas journalist Molly Ivins, I-V-I-N-S, iconist class herself, offers some explanations on why Melnick-Kontinsky describes our professional legal talent as scum. A lawyer named Hurd was to have been named the next president of the Texas Bar Association. At the height of his campaign, he was picked up during a police raid on a nude modeling studio. The Bar Association reluctantly chose another candidate as president. Another prominent attorney makes the news, and charges usually found only in a supermarket weekly, such as the Star. Marvin Michelson, who invented the concept of palimony, for his discarded lovers of Hollywood movie stars was charged with professional misconduct after complaints originally from actress Julia Newmar and Eleanor Robertson of the Cosmetic family. The complaints including charging excessive fees, failing to place a client's funds in trust funds, and an allegation of moral turpitude, and that he allegedly refused to pay $1 million for jewelry bought in Switzerland in April 1987. The two pieces of jewelry from the collection of the late Duchess of Windsor had been auctioned in Geneva. The AP story dated December 6, 1988, noted that the Bar Association now had more than 20 complaints against Michelson, which would be handled as a disciplinary hearing. On January 15, 1989, Michelson was ordered to pay interest and attorney fees on the $1 million from April 1987 when he took possession of the jewelry. Although he has claimed that the money was not due until October 21, 1988. His fellow California lawyer, Melvin Belli, known as the King of Torts, was written up in the Wall Street Journal as an exile from his 25-room San Francisco mansion, a local tourist attraction. After a court order was obtained by his wife, now legally separated, he lives on a 105-foot yacht. Although his staff has now been reduced to 13 attorneys, Belli estimates that he has won more than $350 million in damages awarded for his clients. In 1985, he lost a malpractice suit, resulting in a $3.8 million judgment against him. 6 more malpractice suits have been filed against him in San Francisco Superior Court. However, this has not discouraged his clients. He currently has 1,000 cases pending, or 70 for each lawyer on his staff. He also faces tax court proceedings in which the government is asking for up to $3 million on transactions involving the San Francisco law office building. Belli vows his revenge, threatening a lawsuit, malicious prosecution, because he sold the building to his children in 1981. Well, these guys are clever, aren't they? The government wants up to $3 million in his gift taxes, stating that the sale was invalid because no money changed hands, nor was a written contract drawn up when the sale supposedly took place. Belli's fame as the King of Torts was built on his mastery of courtroom drama. He pioneered demonstrative exhibits such as blood-stained bandages, gory pictures, and other materials which shocked the jury members into making large awards. If there's one word which describes the activities of the legal profession, that word is bribery. However, this practice is less important in the poorest areas of the nation than the equally effective forces of intimidation. Bribery reaches an apogee in the large cities and among the major law firms, which handles multi-million-dollar cases. In small town, money rarely changes hand because the legal system functions on political influences, fraternity ties, and a ubiquitous club laid along the rear of the neck. There is a certain noblesse oblique, that is, I owe you and you owe me, or one hand washes the other. The latter was the favorite saving of an attorney with whom I worked for several years. Few legal bribery cases are ever brought to the attention of the public. However, one such case involving the August Wall Street law firm of Cravath, Cravath, Schwab, and Moore exposed the activities of one of the firm's senior partner, Hoyt Augustus Moore. In the early 1930s, Moore was legal counsel for the giant Bethlehem Steel Company, a J.P. Morgan enterprise. This firm, in the course of its monopoly, tried to take over a competitor in the wire rope field, a practice is supposedly forbidden under the stringent terms of the Sherman Antitrust Act. It seemed that a federal judge, that is Judge Albert W. Johnson, would uphold the decision against Bethlehem Steel. However, Johnson, wishing to appear as a reasonable man, let it be known that for a token payment of $250,000, equivalent of $5 million in 1989 funds, he could persuade to withdraw his objection to the takeover. In later testimony before a congressional committee, Councilman Moore stated that this amount is not excessive and not ejectable. Payment was delivered forthwith, despite his public acknowledgement that he had committed the crime of bribing a federal judge. Hoyt Augustus Moore continued his distinguished legal career for some 25 years after the event. In 1959, he retired at the age of 88. Not only did the New York Bar Association ignore his admission of a crime, Judge Johnson was later elected president of his own bar association. He later was indicted for bribery and conspiracy, but he won acquittal after his co-conspirators refused to testify in the case. In September of 1978, Mahlon Perkins Jr., the senior partner of another Syracusan Wall Street law firm, Donovan Leisure, has been founded by General Wild Bill Donovan, a World War I hero who later organized the Office of Strategic Services under the British auspices during World War II, later reorganized as the present CIA. Pleaded guilty to lying on the open. He stated that he had previously destroyed certain documents that his opponents in an antitrust lawsuit had obtained court orders that he produced. Not only did Perkins lose the case, a verdict of $81.5 million was rendered against his firm. Perkins was sentenced to serve 1 month in prison, but the Bar Association refused to take any action against him. If the Bar Association can ignore crimes of this gravity, how could anyone believe that they could take action on a complaint of a private citizen? Indictments against leading members of the legal profession could be cited for many pages. There will suffice to make the point. The fact remains, however, that the greatest damage they have inflicted has been the betrayal of the nation through their activities in international conspiracy. We have cited John Forrester Dulles, although he is the most notorious of conspirators. He is not lacked from emulators on many lesser levels. The Wall Street Journal has noted that his firm, Sullivan & Cromwell, seemed to have lost much of its clout and its important clients in recent years. No doubt it requires a partner capable of similar intrigues before enormous fees are renewed. Present legal practice in the experience of the present writer consists almost entirely of the game known as let's make a deal. The result of this practice is that few lawyers today have a working knowledge of legal strategy or even the requirement of writing a simple motion. Early on in my appearance in our courts, I discovered that I was creating consternation in the ranks of these non-practicing lawyers because of the scope and length of my legal briefs. Because of my many years of training and practice as a researcher and writer, I had no objection to spending many hours reading such legal tomes at the U.S. Code, United States Code, or the Corpus Juris Secundum, books which my opponents rarely open. As a result, the judges were hard put to deny my motions in the face of the feeble efforts of the distinguished colleagues. However, this never prevented them from doing so. Their only hope was that after persistent rejections on every level of court, I would run out of funds or I would become discouraged and go away. In fact, I stayed on to see just how corrupt the system actually was. It was a fascinating experience. The most tried and true technique of exhausting the opponent, that is, by wiping out their financial resources, did not work in my case. I was not paying the expense of a large law firm or a single lawyer to handle my work. My greatest expense was typing paper and ribbons, perhaps $10 a month. The expenditures enabled me to keep 6 or 8 cases going in state and federal courts. However, my best efforts were usually torpedoed through the legal techniques of discovery. Briefly stated, discovery entails an order from the court that you turn over all documents and evidence of your case to your opponent so that he will then have the weapons to fight you. Isn't it amazing, folks? It's a stacked deck. It's a fucking stacked deck. Opposing lawyers sift through all of your documentation, strike all the evidence favorable to you, and have the judge declare it inadmissible. At the same time, all evidence favorable to their side will automatically be ruled as admissible by the judge. In 40 years of court practice, I never saw this practice overlooked, nor did I ever see it fail to produce a decision against me. These people are despicable folks. Discovery also required what I call prolonged appearances and pretrial depositions, providing answers to lengthy questionnaires known as written interrogations and answers to requests for admission. And those procedures fail to destroy you. The court then goes to the order for production of documents. Usually this means that the court orders you to produce your great-grandfather's passport and similar papers which have not been seen by anyone for many years. Failure to do so results in immediate court sanctions, including indefinite jail sentences, until the documents are produced. Discovery techniques on which present legal practice depends constitutes, first of all, a trial of the case by the opposing lawyer without benefit of judge or jury, and second, a bill of attainder against the party who is ordered to appear. Bills of attainder are strictly prohibited by the Constitution of the United States, yet every judge to whom I made this notice ignored it. At that time, I did not, you see how corrupt the system is, folks? I did not understand that the admiral law of England had subsumed the Constitution of American courts. Bills of attainment are not prohibited in the admiralty church. bills of attainder are not prohibited in admirable law. You see, Roy Combe, reputed to be a fierce opponent in a cover and writes his own autobiography and a Hall of Fame example of the tail wagging the dog. Discovery has become the be-all, the end-all of trial practices. Years are spent in discovering the other fellow's case in the privacy of conference rooms is brilliantly decorated. Law offices paid for by clients who are supposed to be getting a fair shake for their money instead are too often getting a shakedown by lawyers who would not know how to try a case before a jury if their lives depend upon it. Depositions is called, and all it does is financially support incompetency who are afraid to show up in court. Coin glosses over the fact that discovery is more often employed to destroy the opponent before trial through protracted expenses and abuse. The Wall Street Journal noted that by September 1988, the Wall Street firm of Drexler, Burnham, and Latimer has spent some $140 million to defend itself against the charges of violation of security laws, a cost which included $40 million for copying 1.5 million pages of documents. The firm finally settled out of court, agreeing to pay $650 million in fines for charges which it might have been able to disprove in court after paying legal costs of double the amount of fine. The Department of Justice came against the giant AT&T company, was also a lawyer's dream, involving the payment of hundreds of millions of dollars in legal costs, in which you, gentle reader, wind up paying through increases in your telephone bill. As you may have suspected, the Department of Justice's largest law firm in the world specializes in creating such lawsuits for the benefit of lawyers everywhere. This explains F. Lee Bailey's cryptic comment on the cold fear associated with being a defendant in American court. M&N Associates, in a poll taken in 1968, found that 68% of American citizens did not believe they could attain a fair trial in any American court. That was in 1968, folks. The famed lawyer Jerry Gerry Spence, Spence, in his most recent book, With Justice for None, writes that the truth is that there is no justice in any court for the American people. The libel suits also remain a fertile field for lawyers, as the judgments and legal expenses have no limits. When two liberal writers of the New York School, Linnegan Hellman and Mary McCartney, went to court against each other, the results was disastrous for both. Hellman had a long record as a habitual liar. As she married a Hollywood scriptwriter, Shields Hammett, she took all the income from his work, refused to allow his children by his previous marriage to receive any funds. However, it was her reputation as the most outrageous liar in a profession not noted for his dedication to the truth, which caused her fellow liberal, Mary McCarthy, to speak in exasperations during a national broadcast interview on the Dick Cavett Show, characterizing Hellman as a holdover, tremendously overrated, a bad writer, and a dishonest writer. She followed this denunciation of Hellman, which might be excused as a legitimate literal criticism, with an actual statement when she included every word she writes is a lie, including and that. And brooding over McCarthy's statement for a few moments, Hellman called her lawyers. In February 1980, Mary McCarthy had to defend herself in a libel suit. Despite the fact that she had long been a darling of the literati and had been many bestsellers, she soon found her savings decimated by legal expenses. Her New York attorneys charged her $35,000 for filing one motion in this case. I sometimes filed 3 and 4 motions in a single day, but I had no comparable expense. The case dragged on, as cases do when one has expenses. New York lawyers, Linnegan Hellman, died in 1984 before the case came to trial. A considerable relief to Mary McCarthy is a truism of a legal professional that one never can predict what a jury might do. The usual award in a libel case of this type is just $1, but punitive damages, which are aptly named, which are purely admirable law, can amount to millions of dollars. Fame unpredictability of juries has now given rise to a new art, the art of jury selection. It is an art, because the final framing of the painting depends entirely on which jurors the lawyers have selected. One might call this the fine art of stacking the jury. Although jury stacking is theoretically illegal, this has never prevented anyone from trying it, though. Members of a jury usually base their final decisions on factors of race and sex, and on the way a defendant, if she's a woman, does her hair. This is understandable when we consider that after days or months of listening to conflicting testimony, most jury members have not the faintest clue as to which party is in the right. In recent decades, juries make up entirely of poor Black Democrats in the District of Columbia criminal cases have routinely voted for the conviction of white, middle-class Republican White House staff members in political show trials. The Watergate trials was the apology of this process, which reached a new wave when the conviction of most of Ronald Reagan's White House staff in recent years. Reagan's closest associates, among them Michael Deaver and Len Notziger, were found guilty on vague charges by Black juries who were perhaps expressing their resentment as having had to endure 300 years of slavery in the United States. At any rate, the crime of which they were accused were beyond the scope of these jurors, whose daily lives were filled with the necessity of surviving in a murderous, drug-saturated environment. The Moscow show trial of Colonel Oliver North continued its brave tradition. Even the Washington Post was driven to the comment of the possibility of injustice because the entire jury was composed of another race. Even the Washington Post forbade to mention the race that dare not speak his name. The reader was left to conjecture whether Colonel North was being tried before a jury of Chinese or perhaps Indians. Our legal system is usually described as an adversary system. The two opposing clients come before the court for impartial judgment by either a judge or jury or by both. In practice, the courtroom's adversary system creates rancor, and hostility on both sides. It precludes processes and solutions which are potentially satisfaction to both litigants because it is more profitable for the attorney to keep them at each other's throats. Each attorney assures his client that he is certain to win, therefore the case must be prosecuted all the way through the court. Instead of arbitration or dispute resolution, which would be much cheaper and more satisfactory to the litigants, they are deluded into going for a total victory. The lawyers gain everything and lose nothing by urging the path. When his client loses, he will try to persuade him to appeal this unjust decision. The result is more fees for the attorney and for the courts. And I'm going to stop there. It's getting late. It's after 12:30 here. We'll continue this tomorrow. Yeah, we're going to stop here. Thank you for listening. We'll continue this maybe tomorrow, the plague of lawyers. Thank you for your attendance. Again, my channel here is Discerning What is True. I know it seems long. Most people probably know some of this stuff, but frankly, you really do need to know these things, folks. You really do. If you really care. The problem is most people don't care. And that's why we're in a mess. Okay. Have a good night. You take care.